Hi guys, welcome back to my channel. So today I'm going to read an article entitled Indonesia as Maritime Country May Face Difficulties in Law Enforcement at Sea. The broad variety of problem and challenge can be found in Indonesian's waters, include coastal area and the sea itself. Indonesia has been involved on making maritime law since UNCLOS 1982, with archipelagic state concept that gave significant implication to the law of the sea. Times change. The problem that occur at sea would be different. Maritime law enforcement would be challenged to be adaptable for the new problems and how Indonesia developed its maritime law to face new challenge. As an archipelagic state with 17,506 island coastlines measuring some 81,000 kilometers and sea area covering about 7.73 million kilometers. Indonesia is facing a need to protect, conserve, and manage its marine and coastal resources. In doing so, it is imperative for the government to consider several interrelated legal and policy strategies to protect and secure nations' jurisdiction at the sea. One of the most important things is enforcing law and order in the marine space that include the territorial seas, inland waters, archipelagic waters and territorial waters, and jurisdictional seas. Supplementary zone Indonesian exclusive zone and continental shelf within those territories and zones. Indonesian maritime laws must be upheld. Law enforcement in Indonesia coastal and marine territories is jointly the responsibility of several national government institutions, depending on which pace the legal process is conducted based on Indonesia's criminal justice system. Briefly, in the pace of investigation, there are some enforcement institutions that play a significant role, namely Indonesian Navy Civil Investigation Officer or PPNS, from some state ministries such as Ministry of Marine Affairs and Fisheries and Finance Ministry, and also the Indonesian Marine Police. In prosecutions pace, there is Attorney General Office or AGO with its high prosecutive office in province level and hundreds of district prosecutions office through the country in each cities and regencies. And in juridical pace, there are district court, high court and supreme court. Especially for fishery cases, there are some fishery courts in coastal cities of regencies. The aim of the paper is to address problem of maritime law enforcement related to some acts and regulation involved the role of investigation institution which contain in some agencies the role of maritime port or Badan Keamanan Laut or Bakamla, the role of the Sea and Coast Guard, the role of AGO, and discussion about court decisions in some cases related to crimes on the sea. Law and regulations in the field of maritime. Law enforcement and crimes occur. Located strategically at the global nexus of the Indian Pacific Oceans, Indonesia is the world's largest archipelagic country. With this vast water of strategic importance, the questions of risk, threats, and security are the heart of Indonesia's policy. Indonesian government put a big effort to protecting its sea territory by declaring many laws. There are some related with the law of the sea in Indonesia, such as Law Number 6 in 1996 concerning Indonesian water law, Number 5, 1983 concerning exclusive economic zone, Law Number 1, 1973 concerning Indonesian Continental Shelf Law 17 2008 concerning shipping law, and number 45 2009 concerning fisheries and law Number 32, 2014, concerning maritime. Through the numbers of laws and regulations concerning maritime are not limited to above mentions, but if we extend to any possible crime can be conducted in the sea, it can be enlarged to the taxation law, labor law, fishery law, investment law, conservation law, oil and gas law, company law, coastal and remote island management law, custom law, anti-corruption law, anti-money laundering law, criminal code, immigration law, environmental law, human rights law, human trafficking law, quarantine law, sea transportation law. Those laws and regulations is reasonably can be implemented since crime can be occur in the sea, can be smuggling of drugs, goods, protected species, spare parts, liquor and people, unlawful activities of export and import, illegal fish catch, human trafficking, people smuggling, modern slavery, and etc. Through with so many laws and regulations, law enforcement in the sea could not be upheld as it should be. There are many obstacles and weaknesses in implementing such as laws and regulations from some perspective. The first one is the lack of coordination among various agencies responsible for enforcement in Indonesia. For the sake of coordination, the government has established the Maritime Security Board or Badan Keamanan Laut to replace the Maritime Security Coordination Board or Badan Koordinasi Keamanan Laut Barkomla. As stipulated in the Law Number 32, 2014 of Maritime, Bakorkamla was established in 1972 and membership of this body is comprised of representatives from the Navy, Police, Custom Ministry of Judicial Affairs and the Attorney General's Office. The establishment of Bakorkamla is meant to be the mechanism to enhance coordination among various law enforcement agencies, although in practice is not an easy thing to do. In this organizational progress, Bakorkamla was becoming Bakamla as regulated in Law Number 32, 2014 of Maritime as Article 59 of this law stated in order to enforce the law within Indonesian territorial and jurisdiction seas, especially in conduct safety patrol and security inside Indonesian's water territorial and jurisdiction sea. Sea Security Agency is established as in function to conduct a security and safety patrol. A question arises whether Bakamla can conduct investigation or not. So time is up. Bye bye and see you on my next video.